Hello, everyone. Welcome and thank you for joining today's webinar, Trademarks, Copyrights, Patents, and Trade Secrets, IP Strategies for Creating Competitive Advantage, brought to you by Friar Levitt. My name is Katie Guglielmo, and I'll be your moderator. I'm the marketing coordinator of Friar Levitt. I would like to introduce you to our speaker today, Dr. Martha M. Rumor. Dr. Martha M. Rumor is Senior Counsel at the Manhattan office of Friar Levitt. She is a pharmacist attorney admitted in New York, New Jersey, and DC bars. She has a PharmD from St. John's University, a MS in Drug Information from Long Island University, a JD from CUNY School of Law, and an LLM in Intellectual Property from the Benjamin N. Cardozo School of Law. Dr. Rumor focuses on pharmacy and healthcare law, pharmaceutical and medical device intellectual property, including all aspects of patent, trademark, and copyright law, and transactional matters, as well as food and drug cosmetic law. She has 20 years of law experience in the area of food and drug cosmetic law and pharmaceutical intellectual property, especially generic pharmaceuticals. She has also worked in the pharmaceutical industry and hospital pharmacy, both at the director level. She taught pharmacy law and drug regulatory affairs at 2 colleges of pharmacy for close to 20 years. She currently teaches food, drug, and cosmetic law at Maurice A. Dean School of Law at Hofstra University. Martha is a frequent lecturer and has 200 publications and presentations. She is a fellow and a former trustee of the American Pharmacists Association. As senior counsel at Friar Levitt, her practice focuses on both intellectual property and food and drug cosmetic law. Before we get started, I just want to note that all lines have been muted. Also, I want to remind you about the Q&A tab at the bottom of your screen. Go ahead and type in your questions throughout the webinar today. We will wait until the end of the presentation to answer those, but we will be sure to get to them, whether it be during this live webinar or in an email following today's presentation. The webinar will be recorded and sent to you in a follow-up email in the next 2 days. So, without any further ado, I'd like to kick things off by welcoming Senior Counsel Dr. Martha Rumor. Dr. Rumor, over to you.
Okay, thank you, Katie, and thank you all for joining today's webinar. I'd like to go over what we're going to cover this time that we have together. We're going to be looking at creating smart value for your healthcare, pharmacy business, and business ventures through IP valuation, using IP assets and trademarks, copyrights, patents, trade secrets as a sword or a shield. Increasing brand value through trademarks. In fact, the main subject of this presentation is going to be trademarks. We'll be looking at what trademarks are, their function and value from a business perspective, and why it's important to protect your trademark and various other practical aspects relating to the registration and enforcement of trademarks. And then finally, we'll look at protecting on those. Sometimes they'll ask me to eat it at my then I can take, and then I say I'm home and Virginia. I'm going to see something like this. So I start wondering, how can I prevent others from stealing the recipe? Importantly, how can I communicate and intellectual property? As a general matter, intellectual property refers to the legal field that involves protection of creations of the mind, and it can take many different forms: trademarks, copyrights, patents, and trade secrets. And we're going to go over each of these in turn. But keep in mind that more than one type of intellectual property can be used to protect something. You can have, for example, a patent on a drug, a trademark on its name, a copyright on the package insert, and the method or process of manufacturing that drug could be a trade secret. In the healthcare field, healthcare intellectual property, it's really, really taken off in the last, 10 years. You can have, for example, process or method patents to a device, a new procedure, a product or a formulation patent for a new drug. But hospitals, ambulatory surgery centers, solo or group physician practices, pharmacies, they may have a registered trademark on their names, on their logos, on their advertising. Healthcare providers are increasingly protecting their publications, their protocols, and their policies and procedures with copyright. You can copyright these things, as well as the web domains, your business relationships. And there's other, things that patient lists, those can be trademarks, trade secrets in some jurisdictions. And there's other IP assets, such as doing business as, assumed name filings. So, all of these in the healthcare realm are considered intellectual property. If you own a business and you care about its reputation, you need a trademark. A trademark name, logo, design, it brands all your products and services, and it conveys intellectual and emotional attributes as yours. It protects you from counterfeit products, imposters. So trademarks can protect names, they can protect logos, and they can ensure that the consumers don't get confused between two brands. So can a trademark be used to prevent copying of my soup recipe? And the answer is no. A trademark can only prevent competitors from using a similar name for my soup or using my logo. So if we look at the definition of a trademark, it's a distinctive sign, symbol, or indicator, which is to identify the particular source of products or services. Trademarks can also be used to distinguish a particular product from other similar or competing products. If someone attempts to use something that's confusingly similar to your trademark, you can protect your revenue stream by preventing competitors from trespassing. So that's the standard for trademark infringement, confusingly similar mark. So trademarks are keys to successful brand, and every business needs to develop a brand as part of a strategic business plan. And you need to target what consumers care about, articulate precise values and qualities that are relevant and of direct interest. And because of the internet and social media platforms, consumers are looking to locate you, and it's much easier if you have a trademark, especially if you're in a crowded market or a crowded sector. Trademarks should emphasize the features that are both important to consumers and quite differentiated from the competitors. And they're especially important for startups because they create brand recognition. Virtually every medical practice, every company should trademark its name, especially if the name doesn't include the name of the owners. So something like Dan Fryer, MD, there's no need to protect that, but the Premier Medical Alliance of New Jersey, you should protect that. I mean, that's a name that you might want to seek a trademark on. You can also obtain trademark for goods and services which you're planning to offer in the future. That would be an intent to use trademark. This slide just shows you how brands are built. So the trademark clearly facilitates consumer choice within the market economy. Differentiation and relevance, those two things go to brand strength. And then once you have a strong trademark and logo, then you're building your brand with esteem, how well regarded the brand is, and knowledge, an intimate understanding, as well as an awareness of the brand. And then that creates the stature that's needed for your brand. And, healthcare businesses, this is so important because say I have 5 urology group practices in New Jersey. I have the Urology Associates, the Urology Associates of New Jersey, the Urology Associates Incorporated, Urologic Associates, and the Urology Group. How is that distinct? How are any of those distinct versus something like a trademark for the Mayo Clinic or the Institute for Urologic Excellence, which stands out? Something like the Children's Hospital or the Children's Medical Center versus branding Cohen's Children's Medical Center or Komansky Children's Hospital or Morgan Stanley Children's Hospital. Those trademarks are more distinct and they create brand for what you have. Looking at the functions of the trademark, it allows companies to mark a territory. You could say, you could add a state, or you could say Northwest, or you could say, so you can mark a territory. You can ensure that the consumers identify the line of products that you have. It also grants exclusive rights to use the mark. And it grants the right to prevent others from using an identical or similar mark for goods or services. The value that the trademarks bring, it's a marketing tool, and it's a source of revenue through licensing. It's a crucial component of franchising agreements, and it's also useful for obtaining banks or third-party finance, as well as being a valuable business asset. Years ago in the healthcare field, there may not have been such an important purpose for trademarks because businesses were small, they were localized, and it really wasn't, critical that a small business, trademark its name. But now with healthcare entities being across state lines, growing practices nationally, mergers and acquisitions, trademarks have taken on a very, very important role. And again, the trademark protection is through registration. So it's an exclusive right, and it secures investment, it promotes consumer loyalty, it provides coverage in relevant markets where businesses operate, and they permit license or the basis for franchise agreements. Some clients, they say they search for the name, they're forming an LLC, they searched for the name, and that protects them. But, that's great. You now have a name, but you're not really IP protected. Your name and your logo are not protected unless you trademark them. There is common law trademark rights. You could have the symbol TM, which is an unregistered trademark, and that means that it has not been registered with the United States Patent and Trademark Office. And the common law trademarks, they're generally valid only within the state in which they're actively being used in commerce. The problem with your common law trademark is that you have to jump through a lot more hoops in order to enforce your mark under the Lanham Act, or to get any kind of damages for anybody that's infringing on your trademark. If you federally register your trademark, then the symbol is that R within the circle. And that's a notice to the public that a particular trademark is federally registered. And it's much more valuable, as I mentioned, than the common law trademark. Once you apply, it usually takes about a year to a year and a half to register. It gets, published and things like that. And while you're waiting for the trademark to get approved, you can use the little the TM symbol versus the R in the circle while you're waiting for your trademark to get approved. Another advantage of registering the trademark is after it's been registered for about 5 years, you can file for incontestability. And that's a very valuable asset when you're trying to sell a business. And the other thing to know about trademarks is that they are relatively inexpensive to obtain. How much does it cost to trademark a business name? It costs very little. It's very inexpensive. It's one of the bargains, federal government bargains versus something like food, drug, FDA fees are enormous if you want to file for something with the FDA. But the United States Patent and Trademark Office, to file for a trademark or a copyright, it's very, very inexpensive versus the benefit that you can obtain for a trademark. We're talking about less than a few $1,000s. So trademark common law provides a notification that there exists a public claim to use a particular trademark. And it's not that difficult to obtain. The first step would be to conduct a trademark search. And you search to see if anyone else is claiming trademark rights in a particular mark. When choosing the trademark for your product, you have to keep in mind that you shouldn't choose something that's going to be rejected by the trademark office. So you don't want to choose something that's a generic term or something like somebody's flag, country's flag, or an emblem, without legal authorization. So before you submit the application, you conduct a search. A search is conducted to make sure that the trademark is not being carved out by somebody else. And not only do we search on the USPTO website, but we also search the state registries to make sure that it's not being used in a particular locale. And, once you have a trademark, you also want to do searches to monitor and make sure that there's nobody that's out there that's trying to, infringe upon your trademark. So you prepare the application, you work with your attorney to prepare an application, you describe your trademark, you figure out when it was first used in commerce, and you describe the products or services which the mark will be used. And then you try to claim as many classifications as you can. So for example, classification 044 is medical services, but maybe you're using it on advertising pieces and things like that. So you'd claim, another category. Once you also need specimens, so you'd need to have photos of how it's being used in commerce. Just to, we upload those photos to the USPTO site as well. And then, once you do that, you submitted this application, then you have to wait for the PTO office to assign an examiner. And so it may take a few months before they assign an examiner, trademark examining attorney. They're assigned to particular categories. So they have a trademark examining attorney who's going to look at, say, all applications for medical practices. And so trademark names for medical practices or trademark names for pharmaceuticals, they have it split up that way. And then they're going to look at that and they're either going to say, this is great and there's no reason why it should be denied registration, and then they'll send a notice. Or they could issue an examiner amendment. They might say they want something to be changed slightly. Or they could issue an office action saying that there's some problem where they see that this trademark is already out there, or that your trademark may be confusingly similar to somebody else's mark. But if they find no reason, the next step is that it gets published in what's known as the Official Gazette, and that's a weekly publication put out by the PTO office. It's a record of all the trademarks that have been approved for publication. And then once it gets published there, you have 30 days. Anybody who thinks that that mark would infringe on their rights, that someone would have 30 days to raise a rebuttal. And that's extremely rare. Only about 3% of all the trademark publications result in some type of opposition. And if there's no rebuttals of your mark, then if all goes well, you're on to registration. You have your trademark officially registered. You get a certificate, it's valid for 10 years, and it can be renewed for a very nominal fee with the trademark, US Patent and Trademark Office. So as I mentioned, you have the registration and then the protection. The other things you can do is you have maintenance through keeping your mark active in the stream of commerce and ensuring that your mark doesn't become generic. You can also, have services that watch for it, or you can do this yourself, making sure that, especially if you want to expand your enterprise in the United States and abroad, you want to make sure that you have your mark listed with various watching services. And the other thing is enforcement, and enforcement is on the owner. So it consists of pursuing adverse users. One particularly often used method is what we call a cease and desist letter. And that usually is very effective, cease and desist letter. There can be litigation, because the cost to rebrand for a company that is very, very expensive and time consuming. It results in a loss in your marketing momentum. And so, filing for a trademark helps to avoid the chance that you'll have to rebrand your company, or, you want to avoid litigation by registering your trademark. There's been some really high profile trademark cases in 2020. There's one case, the USPTO versus Booking.com. And Booking.com, as you know, is a digital travel company. And the USPTO, they had a rule that said that something like booking, would be a generic term. And just adding the word com to it, it's still a generic term, and you can't get a trademark on that. And that case went all the way up to the Supreme Court. It was, in fact, Justice Ginsburg's last case that she looked at. And the Supreme Court ruled that it's okay to use a generic term with com, because in this particular case, the consumers see this as a brand name, Booking.com. So that's how that case was decided. There's another case, Rome Jag Fasteners versus Fossil Group. And that case revolved around whether or not willfulness is a prerequisite to an award of profits under the Lanham Act. So can you seek damages from somebody that's an innocent infringer? Can they have their profits disgorged for infringing on somebody else's trademark? And the circuits had been split on this throughout the country. The circuit courts were split on this issue as to whether willfulness is a prerequisite to an award for profits under the Lanham Act. And again, the Supreme Court got involved in this trademark case and said, no, you don't have to be willfully infringing. You can be an innocent infringement and still have, still be held accountable. So enforcing trademarks, as I mentioned, the rebranding is expensive. Trademarks will safeguard against things like cyber squatting, where cyber squatting is where somebody that's registering, using, or trafficking in internet domain names with a bad intent to profit from the trademark of somebody else. And so there's this Anti-Cyber Squatting Consumer Protection Act, and a trademark owner, if you own a trademark, you can sue for those that are trying to register a domain name that's even similar to yours. Post-registration enforcement, non-use, I have there on the bottom, the yellow arrow. The expression, either use it or lose it. After a particular period of time, if the mark is not being used in commerce, it might be deemed abandoned. So you want to be using that trademark on your goods and services. You want to affix it to packaging, advertising. And again, the trademark is a no-brainer considering the costs involved. So can I copyright my recipe? Copyrights. Copyright grants an exclusive right to use via the authorship of an original work. And my recipe is an original work, isn't it? It is, but the copyright is for literary expression. So recipes are difficult to protect via copyright because no matter how delicious they are, they often lack the necessary literary expression. But let's say I develop a collection of my soup recipes, like a cookbook, then that can be copyrighted. But just listing the soup ingredients, just listing them somewhere, that's not enough. Maybe, listing them and adding commentary or creatively selecting certain recipes, then, maybe that's copyrightable. Copyright protects, it grants exclusive rights of use to the authorship of an original work. And copyrights are good for the life of the author plus 70 years. And you can go online, you can find a list of books and films that have entered the public domain. So it's the life of the author plus 70 years. So in January 1st of 2021, anyone can now go and remix George Gershwin's Rhapsody in Blue because the copyright has expired. So it's, if you're looking to see what's now in the public domain, you can find that very easily. A lot of films, a lot of books, and you're able to use that content. The copyright has expired. People use copyright and trademarks interchangeably, but they're very, very different. If you want to protect an entire blog post or a photo, then you need a copyright. If you want to protect the name of your website or your logo, then you use a trademark. So as I mentioned, copyrights protect works of authorship, whether they're published or not. And it's not just for writers and artists anymore. Personal or business related websites that contain, if the website contains written graphic materials that are original works, then you would want to protect those with copyrights. Website publishers, they're often the victims of copyright infringement by what they call content thieves, which they will think nothing of copying somebody's work from their website and passing it off as their own. You can use your copyrights for your policies and procedures. You can copyright your articles that you publish, books, things like that. There's really no legal leverage if somebody decides to steal articles and content off your website if you haven't, registered your copyright. The only thing you can do there is to send that cease and desist letter, but you won't be able to get any compensation for that. So you can't sue for copyright infringement unless you've actually officially filed for a copyright. And if you register the copyright, then you can also be eligible for statutory damages and attorney fees if a lawsuit is successful. The more your website is, the better it is, the more likely it is that some competitor will try to use your written content or the images or some elements from your website and present them as their own. And so if you don't copyright your website, you might be unable to recover the damages. So how do you file for copyright? You have to be the original author, or the original author has to give you permission to file for a copyright. You file for copyrights like trademarks. They're filed online at the US Copyright Office. And it takes about 6 to 8 months if you file online. And the fee at the patent office is a couple of $100s. So again, it's relatively inexpensive. It's a federal bargain. And, on the bottom of most, for example, websites, you see that little C symbol with words like all rights reserved. So, putting that is important because it's a deterrent. And sometimes, that you'll see that symbol, and even if somebody hasn't filed for a copyright, they're putting that on their website, which is okay. Even if you don't file for a copyright, you can put that on your website. It's not illegal, but it can be very difficult to prosecute infringers. You're putting that little C, but you really have no teeth behind it. So if your content is valuable and most businesses would agree that their website is valuable, then it's worthwhile to obtain a copyright registration. When you're working with contractors, independent contractors, you want to make it clear as possible who owns what. I mean, things like website content developers or software companies, somebody's producing a product for you. It's very, very important in the agreement to spell out who owns what. You don't want, after the agreement has ended for whatever reason, for the content developer to then try and say, well, this is mine, and you can no longer use that on your website. So those things have to be spelled out with the contractors. You can copyright computer software, the literary expression. It's considered literary expression, and so you can copyright that. You can't copyright things like facts, a compilation of facts, like a phone book, ideas, methods of operation, systems, something that's intangible. Those things cannot be, those are some of the 5 things that you really can't copyright. Joint copyright ownership, I just touch on it real briefly. Sometimes it can't be avoided, but it keeps us intellectual property attorneys very busy, because if somebody owns something jointly, things were, relationship was good in the beginning, you all own a piece of the copyright, you all own it equally, which means you all can license it non-exclusively to someone else. You all can commercialize it. You all have equal rights in the copyright, unless you have some collaborative arrangement or agreement that you negotiated up front. And so the issue is, you can all do this, you all have liberty, but then you all have to share the profits among the co-owners. With copyright, there's something called a derivative work, which is like if you improve whatever you copyrighted, and those improvements, they can be a little tricky, because who owns it if it's joint? That could be an issue if there's a joint ownership of the original material. So the next thing is patents, and I love patents, because that's how I'm a patent attorney. That's how I started, and I can patent my soup. There's no question about it. But the answer is, why would I? The patents are probably not a good method of protecting a recipe, because they're rather expensive to obtain, and they take a long time. I might be able to patent a method for preparing my soup, but again, I might have a hard time proving novelty, that the recipe was never known before the filing date. So patents for breakthrough drugs, yes. For soup, not so much. A patent protection is like a monopoly. It grants an exclusive rights to use the invention or the discovery. It's any new and useful process. So that's what you have to show. You have to show novelty. It can't be obvious. It could be a process, a machine, an article of manufacture, a composition of matter, or any new and useful improvement thereof. Anything under the sun made by man. If you are an inventor, then you do need a patent. It creates the monopoly for 20 years. It's an exclusionary right. And so it prevents anybody else from making, using, selling, offering for sale for 20 years from filing. And that was one of the reasons why the whole Hatch-Waxman Act came into being, because that act extends the pharmaceutical patents by up to 5 years. And the reason is that these companies applied for patents, and then it takes so long to get a drug approved, the clinical trials. And meanwhile, their patents were ticking away. And some of them, by the time they got the drug approved, they only had 10 years left on their patent. So the Hatch-Waxman Act extended the pharmaceutical patents by up to 5 years. There are different kinds of patents. There's a utility patent, which is on a product or process, and you can have a patent on ornamental aspects of your product, that you can have a patent on the, various aspects of the product that are ornamental, the shape of a tablet, stuff like that. You can get a patent on those if they're novel enough. The full patent versus a provisional patent application. So a provisional patent application is like a placeholder. As I mentioned, the full patent could take a long time. It's expensive. And so a provisional patent application is a placeholder for your ideas while you're trying to license it. So you file a provisional application. It's very inexpensive. And then you can say patent pending, and you can spend a year trying to license the thing. And after that year is up, then you have to file a full, patent application. Or if it's licensed, somebody else can have the expenses of going through the process of getting the full patent on it. The important thing to keep in mind is that you don't want to be marketing an invention before filing a patent application. Yes, there are people out there that you go and you present your idea, and you haven't filed a provisional or a regular patent, and the next thing you know, they've stolen the idea. And unfortunately, the US is a first to file system rather than a first to invent system. So if somebody steals your idea, you may actually be forfeiting the ability to secure a patent. So you want to market, you want to test the product in the market, but your competition could steal it, they could file a patent, and you won't even know that for 12 months because it takes 12 months before an application is actually published. So you would really not even know that. There are other bars to patentability, for example, public use, printed publication, an offer for sale to a third party for a contract for manufacturing. Those things can be considered an offer for sale. And you do have that 1 year grace period, but as I mentioned, don't do it, because if the third party gives a public demo or makes an offer for sale or distributes a printed publication, that's going to be a bar to patenting. It's considered prior art, even against what you're trying to file. So increased profits and prices, that all depends on market demand. And so since it's a monopoly, you can stop others from selling a competitive alternative. So basically you can charge more for a product, and it levels a playing field. So even a large company versus a small company has the same rights under a patent as a large company. And so you can stop a large company from competing against you because you have a patent. A market demand, just to mention, a patent doesn't help increase market demand for a product. So for that reason, a patent is most useful for products for which there is originally a large market demand. And if you have a high demand and you have the patent, then it prevents others from introducing their versions of the patented product. That would be infringement. So you can sell your product at a higher price under this system. For example, i.e. pharmaceuticals. That's one of the reasons why the prices, they have patents. There's a high demand for these breakthrough drugs. And so you can have a product that will cost a patient, $400,000 plus for a course of therapy. And you can have patents to all kinds of things. There's, various patents out there that some of them are, although this one might be quite useful. And then these are the reasons why I became a patent attorney. I'm kind of partial to this pat on the back apparatus. Just saying, I could use that occasionally. But there's a lot of different patents out there for all sorts of crazy things. So the next thing I want to talk about is using intellectual property as a business asset. And so it's important when a business is being valued and sold Intangible assets like trademarks and goodwill, they're of utmost importance when it comes to mergers and acquisitions, sales, licensing, franchising. These non-financial assets can really dominate the valuation of businesses. Your IP portfolio includes all intangible assets such as patents, trademarks, copyrights. The IP due diligence is mandatory before you make a purchase of the intellectual property or any kind of a merger or acquisition. Any kind of defect in conducting your IP due diligence can lead to a less than reasonable deal. And a highly healthy, IP due diligence test that can look at the validity of certain assumptions about the IP. So for example, suppose a target company owns a copyright on a series of published manuals. So they decide to determine the value of the copyright by assuming the cash flows in the future from the sale of these manuals. The IP due diligence is going to check whether the assumption is valid or whether the manuals are going to bring in the assumed sales or not. And so that helps the investors in avoiding any defects in the assumption and for reaching a fair bargain in a merger and acquisition deal. Your IP can be a sword, it could be a shield. It can be defensive, it can be offensive. On the buyer's side, it's offensive. That due diligence, if you're a buyer, then you're going to ask questions like, is the price quoted by the seller for the IP, is that value for money? Is the IP transferable? Is it strong? What is the strength of the scope of a patent? Is it strong? Is the company's brand and logo, is the company's name branded? Is the logo branded? Is there any litigation? So that's from the buyer's side. From the seller's perspective, they have to disclose any intellectual property and the actual rights. Because if a buyer uses intellectual property that the seller didn't possess, then the seller could ultimately, be responsible or liable if they didn't properly disclose that intellectual property. So, both sides want the best for their dollars, and due diligence, intellectual property due diligence, it protects both the buyer and the seller to understand the risks involved in the deal of certain IP. So valuation and due diligence, we'll look a little bit at this. The IP due diligence investigation is necessary whenever there's a sale or purchase, and it should be conducted as early as possible. When you're using a checklist, it really helps to define the purpose of the transaction. So it's an important thing to do when you're doing a due diligence investigation, to use a checklist and to define the purpose of the transaction, to look at the IP ownership, to look at any possible third-party owners, to look at the scope of the protection, the enforceability. The due diligence search should look to see if there's been any litigation. And so those answers, will be the results. If the IP should or shouldn't be purchased or sold. If it's an FDA regulated intellectual property or the product is not FDA approved, then that's a whole other layer of analysis in the evaluation. It's best done by an IP attorney. You see this do-it-yourself lighting kit. Don't try this at home. Hire an IP attorney. You can identify the IP assets. Attorneys can do this. They can value the assets for you. They can assess the quality of the IP, the scope of the patents, infringement, and with regard to infringement, again, does the company have internal monitors to look for IP infringement? These are all important things. An IP attorney will conduct the IP audit when preparing for the sale and assist with any negotiations for sale or purchases, or if you hire any contractors. Do the SEC filings correctly reflect the valuation of the IP? Some IP is actually considered a capital asset, so you're going to record that on the balance sheet as an intangible asset. Trade secrets, not so much. It's usually not in the SEC filings, but the other IP is usually a capital asset. Any negotiations following the sale or purchase, they're considered ancillary, and an IP attorney can help with those as well. We didn't talk too much about the independent contractors or the consultant agreements. And you have to be careful there because they might be hired to do a specific R&D project. That in and itself might give rise to some unanticipated intellectual property developments. And the ownership of those rights has to be exclusively negotiated. You're the company, you paid for the creation of this contractor's work product, and you typically want outright ownership of all associated intellectual property rights. But the contractor or the consultant, in turn, they commonly seek to retain ownership of these IP rights, subject to a limited license granted to the company. Even if the contractor agrees to the company's ownership of this newly created work, the work product created may actually incorporate pre-existing contractor materials, and the contractor may need to provide those materials in the services that they provide to other clients. So all of this has to be discussed and negotiated up front. And the parties' respective IP counsel plays a crucial role in drafting the agreements that reflect their own clients' expectations. So you want to make sure that you have the appropriate contract language to apportion rights according to the parties' expectations. So that brings us to trade secrets. And there you have it. Many famous recipes are maintained as trade secrets, i.e. the Coca-Cola formula. So the best protection for my soup may be as a trade secret. And a trade secret is information that a company chooses not to share, and it's only available as long as it remains a secret. Trade secret grants exclusive rights of use for any formula, practice, process, design, instrument, pattern, or compilation of information which is not generally known or reasonably ascertainable, by which a business can obtain an economic advantage over competitors or customers. The 2016 Defend Trade Secrets Act, that established the rules of the game for trade secrets. And you need non-disclosure agreements. If you're going to be relying on trade secrets, then you really need non-disclosure agreements with your contractors, your manufacturers, your distributors, as well as anyone else who came into contact with the secret. The disadvantage of trade secrets, someone could just, reverse engineer it, and then they could use the secret. The other thing with trade secrets is litigation right now is a little tricky for trade secrets because the claim that would be made in these cases is misappropriation. Trade secret misappropriation. But there's a growing body of law that requires the trade secret plaintiffs to identify their trade secrets that are alleged with reasonable particularity in an initial trade secret disclosure statement before the defendant is required to respond to the plaintiff's trade secret related discovery requests. Now, this is problematic because the trade secret complaints that are filed, they rarely identify the trade secrets in the suit with any particularity because they're trade secrets, and the plaintiffs want to delay that identification as much as possible. So, that's one of the issues, with the litigation. The patents offer stronger protection, the best protection for an invention, but as I mentioned, they're expensive, they take a long time to obtain, you have to establish novelty. And, by the way, they only last for 20 years. So another option that's being used increasingly is the trade secret, but because of that, there's been a tremendous increase in trade secret litigation. If it's a trade secret, also, you have to treat it as a trade secret. You have to label any documents as confidential. I'm going to talk about this on the next slide. Just because something is labeled as confidential doesn't necessarily make it a trade secret, but anything that is a trade secret is necessarily confidential. There's no time limit, they can last forever, but there are certain elements that make something a trade secret or not. So for example, it can't be known or readily accessible by competitors. So, if you're a PBM and you have your PBM manual on the internet, it's no longer a trade secret. It's out there. If it has to be something that has commercial value or that provides a competitive advantage in the marketplace, the owner of the information has to protect it from disclosure through reasonable efforts to maintain its secrecy. Things like, marking it confidential, not broadly, distributing it, stuff like that. So some of the latest trends in trade secret law, first of all, trade secrets, almost every state defines them under the Uniform Trade Secrets Act. And like I mentioned, they're a subset of confidential information. So information that is confidential may be things like contracts, agreements, employment agreements, non-disclosure agreements, letters of intent, purchase and sale agreements. Those contracts and agreements, they may define the scope of what's considered protectable, as well as the consequences of misuse of that information. So confidential information could be any information about a business that's not generally known to the public. And the category of protectable confidential information would be much more encompassing than a business's trade secrets. So all businesses need to conduct an internal audit to identify what it considers as a trade secret and what does it consider as confidential information. And so after that determination is made, then a business can put into place the necessary protections, such as agreements with employees and with third parties that receive access to the information, internal and external security measures, internal policies and procedures, and ways to, monitor compliance. And then, with trade secrets, once there's a breach of a trade secret, once that's identified, then a prompt action is required to address any misappropriation or misuse. Because if you fail to respond to a breach, then that may constitute, a waiver of some sort. The trademark litigation, it's on an upward trajectory each year. And one of the reasons is patent invalidation. And there's been a lot more patent invalidations recently. And another reason is workforce mobility issues and technology such as digitalization. Those are all reasons why there's been an increase in litigation aspects of the trade secrets. The healthcare sector, it's been one of the steepest increases in litigation. And like I say, it's keeping trademark attorney, the trade secrets attorneys keeping us very busy. There's been more uses of trade secrets for computer technology, programming, methods, source code, customer lists, proprietary pricing, and supplier relationships. And this is my contact in case you have any questions, we don't get to today. We have about, 7 minutes for Q&A. And, don't feel, if I don't get to your question, you could shoot me an email, or I'm going to look at the questions that you've submitted online, and I'll be answering each and every one of them.
Yes, thank you, Martha.
With that, it up.
So we've received a couple questions. Our first question is, can a confidentiality agreement protect like a patent application?
So, okay, that's a good question. And the bottom line is that a contract something like a confidentiality agreement or a non-disclosure agreement. Those and patent applications, they protect your interests in different ways. So, a course of action would be to have both. You can file a patent application and have the investors and the licensees execute a confidentiality agreement to protect yourself. If you don't have the funds to do both, then I assume you're going to do the lower cost of the two, which is namely the confidentiality agreement. And so, that's, you have to understand the risks. There are risks of relying solely on a confidentiality agreement, to protect yourself. And I mentioned that when I spoke about, the patent rights. So you may have this confidentiality agreement, but, you're going to have have the burden of proof of which ideas you actually disclosed. Even if you have investors or licensees sign an onerous confidentiality agreement, you still have the burden of proof, and you have to show which ideas that you disclosed. So one of the ways to get around this, if you have something that is worthwhile to patent, is to do that provisional application, and then you have that year to try to license it. You have a placeholder. You've kind of disclosed what the invention is, briefly to the Patent and Trademark Office. And so that's one way to approach that.
All right, thank you. We received another question. I read about the USPTO having some type of new program because of COVID-19. Have you ever heard of this?
So, yeah, the U.S. Patent and Trademark Office right now, they have, and they've never done this before, so this is unique. They have a COVID-19 trademark prioritized examination program, and they have a prioritized program for patent applications. And so, for trademarks, it allows COVID-19 related trademark applications to be advanced at a turn and immediately assigned for examination. And so, it can shave off, several months or more from the review of your trademark. They've also waived a fee that's usually required for expedited review requests. So they're going to review it at a turn. They're going to, take months off, and you don't have to pay for an expedited review, which, it's not that much money, but an expedited review, to have your trademark reviewed at a turn can cost like $1,000 or so. And so they've waived that fee. But again, it has to be a COVID-related medical product or service. It has to be something like a pharmaceutical product or a medical device, like a personal protective for COVID. And for patents, this is really wonderful, because for patents, the average time to get a patent application from the Patent and Trademark Office is 24 months. And if it's a pharmaceutical product, it's even longer. And so this, what they've decided to do is, again, they're going to expedite it. So it has to be a product that's applicable to FDA approval for COVID-19 use. Doesn't have to be FDA approved, but it has to be something that you're planning on. It's a product that the FDA could approve, a medical device, a pharmaceutical, a process, something like that. They had originally capped it at 500, but it looks like they've expanded the program. And so that can be a financial windfall for a company. It can add patent life, and it can cut, patent prosecution costs. They're also expediting an appeal process. So if somebody tries to, invalidate your patent, some kind of an appeal, speed up a patent examination or ex parte appeals. And so that can be, the time for that can be cut in half with this program.
Great. We have time for one more question. What are some IP provision type clauses to add to independent contractor and consultant agreements?
So, like I mentioned, it's really important. There are some things to look out for when you're negotiating and drafting these agreements. But you want to, make sure the key clauses for the deliverables, the work product, any pre-existing material, what we call background material. You want to, review those definitions in combination with one another. You want to make sure that they cover or exclude certain, items. You want to, make sure if it's a contractor that you hired, that they're assigning the IP rights to you. Or if it's work for hire for certain copyrightable works like software, you want to make sure the copyright's going to vest in the company and not remain with the contractor. You want to try for that. You want to, look at the license terms, make sure that, see if the license is perpetual, specific period of time. You want to look for, if, third parties who could come into the ownership, things like that, whether the license is transferable, all of these things have to be looked at.
Wonderful. Well, thank you so much for this presentation, Martha. And everyone, thank you for joining today's webinar, Trademarks, Copyrights, Patents, and Trade Secrets, IP Strategies for Creating Competitive Advantage.
Thank you,
Again, please see Dr. Rumore's contact information if you have any other questions or concerns. You will be receiving a recording in a follow-up email within a few days. This concludes today's webinar. Thank you and have a great day.